Hi, everyone. My name is Ian Mitra. I'm the editor of the Texas Tribune and also a proud board member with the Freedom of Information Foundation of Texas. I'd like to welcome you all to this panel on navigating, telling difficult stories and navigating roadblocks. This is the most important panel of the day because it's the only one that keeps you from lunch, so we'll get right to it. I'd like to start off by introducing our panelists here. I would start off with Joe Ellis. He's the executive producer of news projects and investigations at KView, the ABC station here in Austin. He's also on the board of the directors of the Freedom of Information Foundation of Texas. Also, we have Elizabeth Findell, who covers city government for the Austin American Statesman, a Colorado ski town native. She's been in Texas about 8 years, previously writing for the Dallas Morning News and in the Rio Grande Valley for the Monitor. Also with us is Andrew Chavez. He's a senior computational journalist at the News. Before that, he worked at the Statesman and at the journalism school at TCU. At the News, he does everything from news apps to data journalism and interactive graphics. Last but not least, John Griffin is a managing partner of the law firm Merrick, Griffin & Knopp, with offices in Victoria and Port Lavaca. He represents various governmental entities and citizens in Open Meetings Act cases. So let's just dive right into it. And Joe, I'll start with you. Earlier this year, in the city of Austin, in what became frequently known as the Austin bomber case, when the bomber Mark Condit was finally caught, there was also records requests that you did on behalf of KView, trying to get videos of him and the arrest, and you ran into what you've run into before, which is citing of the law enforcement exception. Could you talk a little bit about kind of what you went through and the kind of the roadblocks you went through when you were reporting that?
Well, anyone who's a journalist in the room knows that the law enforcement exception is very general, broad, and it gives law enforcement agencies a lot of discretion with what they release. There's only a few situations where, really only one, where law enforcement agencies have to provide you information about criminal suspects, and that is when there is a conviction or a deferred adjudication in a case. That's about the only time they absolutely have to give you everything in the investigative file that led up to the prosecution of the individual. With the case of the bomber, they claimed whenever we requested that they provide the videos, because it was revealed by the chief that the bomber, Mark Condit, had recorded videos of himself, whether audio or video. There were recordings over those weeks of time where he was setting off bombs across the city. We felt there was a great public interest in that because we never really got to the bottom of what was going on in this person's mind, what was the motivation, and what more could the public learn from it. The chief in his press conference later that day, us and the Austin American Statesman were the first to report who he was. Whenever they snared him that night and he blew himself up. And the chief talked about the existence of these videos, but adamantly declared that he was not going to release them when asked. Watching that press conference that very second, I went over to my computer and I made an open records request for it. Of course, the 10 days went past, and we got the 10-day letter saying that they were going to appeal to the AG. And of course, I wasn't the only one. There were dozens of media agencies that requested that information, thus confirming the large public interest in it. It went to the AG, and they cited pending investigation, which is that's understandable, but whenever you have a dead suspect, a lot of times when before the prosecution actually occurs and the investigation is pending, it might be understandable that they can't release that information during that time. But whenever you have a dead suspect, it should not be very long before they knew he was acting alone. Shouldn't be very long before that investigation is concluded, and so basically, under that exception, we still do not have access to that information. However, the Austin Police Department and the Department of Public Safety has at their own discretion, released the aerial surveillance video of what happened that night whenever they snared the bomber, and ultimately he blew himself up. So that just kind of goes back to what I was talking about, how much discretion they have under the law and what they can release. Yet they're still claiming that the investigation is open, even though they've kind of shown that it's closed. They interviewed everybody else involved. There are no other suspects involved. This guy was working alone. They interviewed his roommates, so on and so forth. But the issue here really is information regarding dead suspects. So beyond the bomber and, and going back decades, it's been widely reported by many news outlets across the state how difficult it is to get information regarding dead suspects who die in custody of law enforcement. Families can't get information about how and why their son or daughter or father died while in jail or while being transported to jail. They may have been arrested for something, but somehow in the process of detention died, and they can't get access to that information. And so, there was a fix to all of this, and maybe we'll talk about that here in a little bit, but I'll let you move on to your next question for
Okay,
now.
great. I'll move on. We'll definitely come back. There's going to be things like the Boeing ruling, how that's affected various aspects of your reporting that we'll get into. But I want to move now to Andrew, who worked on the amazing Pain and Profit series with David McSwain at the Dallas Morning News. I was wondering if you could talk a little bit about the project and not just like what you actually found, but just the data requests that you had to make and kind of what you had to do to get those data requests from the Health and Human Services Commission and kind of the back and forth you dealt with.
Sure. So this was by far the most FOIA-heavy project that I think either of us had ever done. And in fact, I looked this morning in our tracker. We'd done 170 requests since we started this project in 16 states. And we had just a little over 70,000 pages of documents when we started writing back in June. So it was a massive undertaking from a FOIA perspective, and most of those were TPIA requests. And a lot of them were pretty straightforward requests. It was give us this thing that is clearly, that is clearly releasable and takes minimal time and minimal redaction, and we didn't go through a lot with those. But the most laborious ones were the requests for data. It was something that we knew was sitting in some database somewhere because we'd seen a form or we'd seen, a process diagram or something that told us that this thing we really wanted to know lived in a database. And in some cases, we spent 4 or 5 months of back and forth going through which fields were releasable and what filters had to be applied to the data for it to be releasable and all those sorts of things. And a lot of it was because we were dealing with so much information that was health information. And we definitely ran into some cases where we felt that it should have been releasable, but that we would probably lose an argument to have it released, but that there was technology and there were solutions available to the agency to make it available to us if they wanted to err on the side of transparency. But we lost a lot of those battles, and there were a lot of those sort of gray areas were pretty tough for us because the laws around getting data and even getting information about what data an agency has have not really kept up with the technology.
Yeah.
Yeah.
You had also talked when we had talked earlier about kind of the these are health records, so
Right.
HIPAA was probably invoked in several of these requests, and did you find like that was invoked in areas where it really didn't apply?
It was, yeah, and there's a tendency to say that something is like the third cousin of a medical record, and therefore it's not a medical record. And there were cases where we were wanting, things de-identified or something like that. And HIPAA does have very explicit standards for how that can be done, and but there's nothing that says that an agency has to follow those practices. That's a if you want to err on the side of transparency and perform this de-identification process on these records, you can, but there's nothing that says anyone has to. you know, and so for a story like this, you know, where we were working so intensely with one agency, it never really, there were a lot of times where we weren't able to make that happen. Yeah.
Elizabeth, I'm kind of waiting for the movie to be made about this, the reporting you guys did on the city manager search. Could you talk a little bit about your reporting and kind of, you know, what you did and, you know, kind of the open meetings issues that you faced while you were reporting on this search?
Yeah, absolutely. As many of you know, Austin was hiring a new city manager last year. And so we had, as you do, put in a records request for the candidates, particularly the finalists, but the city did not provide those documents, arguing that Boeing applied and that they were in competition with other cities for top candidates. So the Statesman filed a lawsuit on that. And then in the meantime, they were interviewing candidates, but they were trying to do so secretly, but the whole council was interviewing them. So they had to set it as a public meeting, although they were having the interviews in executive session. So they had set a public meeting for the Hilton Hotel down by the airport, that circular hotel. And so I and my City Hall partner, Phil, went down there to try to stake out the interviews. And they were doing it, and they had an executive session room, and there were basically two doors to the room, one indoor and one outdoor. And so we were able to kind of stake out both areas as they were trying to get candidates in and out. And we were like tweeting photos of these people and saying, can anyone identify them? And that worked amazingly. I didn't realize my Twitter had as strong of a reach as it did until people up in Minnesota were saying, oh yeah, that's the Minneapolis city manager. So that was they had 2 days of interviews. So that was the first day, and we were able to identify 4 of the 5 candidates who they brought in. The 5th one we were unable to, only because they basically led her into the room while she had a big binder in front of her face, and that video did wonders on the internet. But so the next day, I guess at some point council and staff had talked and said, this can't happen again, we need to do something different. So when we went in for the next day of interviews, which was 2 days later, they called the meeting to order in the hotel as they had before, and then the whole council just booked it out the back door and hopped into vans and took off. And we didn't know where they were going. And Phil tried to follow them initially in his car, and he was blocked when a city employee, you know, swung a gate shut and padlocked it and wouldn't let him out of the parking lot. So then he called me, and I hopped in my car, went out the other side of the parking lot, but I didn't know where they had gone. The city owns some buildings in that area, so I was just sort of like running through these random administrative buildings looking for the council. Eventually found out that they had gone to the airport, and they were in a meeting room behind TSA security that was not accessible to anyone without a boarding pass. Went to the airport, argued with the airport staff for a little while, couldn't get back there. By coincidence, we happened to have a freelance photographer that day who was flying out later in the afternoon. So he did have a boarding pass, so we sent him back there, but he wasn't able to get any photographs. I guess there must have been multiple entrances to that room as well. We were able to identify one of the candidates who interviewed that day through sourcing, but otherwise were stopped. And so then the Statesman added that an Open Meetings Act complaint to their lawsuit, because we felt very strongly that that was very illegal. And we later got a lot of emails back between the council and the search firm and the candidates themselves, where the search firm they used had been instructing the candidates to wear wigs, disguises, pretend to be tourists when they were checking into the hotel, because one of them I had identified when I caught him checking into the hotel. And so, yeah, that was some drama. Ultimately, there was some, I think the city didn't look great in all of this, and so ultimately they did release the information that we had requested and release the finalist names and brought finalists in for interviews, but it wasn't until, after all of this had gone down. Yeah, it was a while later. So that was that, but the open meeting aspect of it was particularly concerning. The city's argument was essentially that going to a different location entirely was no different than going to a different room in City Hall to hold executive session, and that as long as they opened and closed it in the posted location, that they weren't violating the act. And I think that's a really dangerous precedent to try to set, because the act doesn't distinguish between posting requirements for open and closed sessions. So if their stance is that all they have to do is open and close the meeting in the posted location, what's to stop them from opening a normal city council meeting in the chambers, hopping in cars, going somewhere else, voting on stuff, and coming back again?
So just, you mentioned the lawsuit that the Statesman filed. So after they released the records, I guess, just curious, what resulted out of the lawsuit, like in itself, with, obviously the records are released, but could this be prevented from happening again?
Well, the Statesman dropped the lawsuit when we got the information that we had requested, so I don't know whether this could happen again.
Yeah, but nothing came specifically out of that, like to affect, yeah. So John, you've had experience with local and state government. Could you talk about, in the context of all these reporting stories, just, from your perspective, why is this happening, and how do you see where we are? Have you seen a big change in kind of access to records and information? Just from your perspective, can you talk a little bit more about what you've seen in terms of the use of the Public Information Act and restrictions?
Sure. Texas, over the past 30 years, the statute hasn't changed that much. We've had a pretty strong Open Meetings Act and Texas Public Information Act, but over the last 20 or 30 years, even though the statute hasn't changed, and up until Boeing and some other decisions recently, largely court decisions vindicated the act very strongly. But we now see, even though you look at TASB, Texas Association of Counties, TML, all of their guidance, it's basically unchanged. But there is, I don't want to say a cottage industry, there is a trend toward the default position being not to produce public records, to make it more difficult for the public to have access to decision-making, budgets, settlement agreements, candidates for city manager, superintendents, whatever it is. And so I have lawyers, I represent governmental entities too, but they tell me that their thought is now to tell them to under-comply. To keep your client out of trouble, never, for example, have a recording of a closed session. Be as brief as you can be and get away with the law and comply with the certified agenda requirement. These are things that we didn't generally see, 20 years ago. So the trend has been for, what's the word I'm looking for, rote noncompliance. And I was coming up here from San Antonio, and Pat Danner is an excellent reporter for the Express News, wrote a story on a settlement of a public official who'd sued after being discharged, and they mediated the case, and they settled the case. Well, Pat asked for the settlement. What's the settlement? They wouldn't tell him, even though it's public dollars. We were talking before we started today. 20 years ago, you wouldn't have a governmental entity actually saying with a straight face, we can't tell you how taxpayers are being spent in settlement of a lawsuit. But that sort of thing has brought us to this point where there are a cottage industry of ways to try not to allow the public access to public information. And, we see interesting alliances, but, closed government cuts across all lines. We heard on the last panel where there was a suit involving solar panels. Some members of the public will think solar panels is a great thing for the environment, this and that and the other. Others may think it's a terrible idea, but that the city council was not willing to give its amortization of when that project would pay off enrages people. It doesn't matter which side of the aisle they're on. Same thing for whether it's a former disgraced Republican congressman that's being hired as a lobbyist for a small port. Well, it cuts across a entirely different set of lines, but it gores everybody's ox. And so it sort of brings people together in that sense, so that the insiders who have got this cottage industry are still dealing with the public. In my view, is 90% doesn't like this notion of concealing public business, whether it be in public information or open meetings. So that's sort of where I see where we are now.
Yeah. So I guess the natural follow-up question to that, which is for the whole panel here, is, which is some of what we addressed in the first panel with the Sunshine Coalition, but what do we do about it? From your perspective, what should we be doing about it beyond, obviously there's the Sunshine Coalition, but how do we address this, or how can we address this individually or organizationally?
Well, I'll take the first stab at it. I think that it takes key people from different constituencies. And I'm all in favor of joint press conferences working together in coalitions, and I lobby for health funding for diabetes with the Texas Diabetes Council. But there are times when legislators are suspicious of people when they're working together. Sort of like the Evangelical Lutheran and the Missouri Synod Lutheran after the 9/11 bombing. They lost trust with each other because they were sitting next to each other in a prayer. So in some ways, I think it takes members who are, the members need to hear from people, from Tea Partiers. They need to hear from progressives. But I'm not sure putting them in the same press conference is necessarily the way to do it. But some Republican Party chairs, some Democratic Party chairs with different legislators would have the same message. We don't want government by secret. We want to know where taxpayers' dollars are going. And we don't want to be told no because it's our government. And so it seems to me having key people, perhaps even asking speaker candidates for the House, what is your thought on how this bill got killed last session? How can we make sure that happened? Do we have your commitment that you're not going to keep taxpayers and the public in the dark about what local government's doing to the taxpayers? So that's one way I see is actually getting key people to advocate for it, not necessarily sitting with people on the other side of the aisle, but to get their licks in that this is goring our ox too. With leftists are having secret government, conservatives are having secret government, but nobody likes it. Period.
I'll add that, and it was probably talked about quite a bit in the last session, which I didn't make all of, but the Sunshine Coalition, obviously it's a strong group, it's a growing group. We need to keep that group growing with all kinds of, it doesn't need to be just media groups or people, vendors that sell data that they get from the public data, is the LexisNexis type folks. It needs to be a larger contingent of the public and influential members of the public. As he alluded to, last session, a set of bills, an omnibus package put together that would have helped in some of these areas, a fix for Boeing, access to dates of birth and, criminal records and police records, dead suspects, bipartisan support on each side, Democrats and Republicans, and it gets to a committee and one committee chair who happens to be heavily backed by contributions from the likes of Boeing is the one who kills it. That's the beast that we have to overcome there somehow.
You mentioned Boeing. I wanted to spend some time talking about that because it sounds like it's impacted, each of your work. And So I was hoping that, each of you could take some time to talk more specifically about how the Boeing ruling has impacted, specifically, not just the projects that you first talked about, but just anything else, and just, really elaborate on, what you've seen with the impact.
Real quick, I'll just say, I mean, it's become an abusive tool that companies doing business with government agencies can apply anytime they want. And a government agency can apply it. And it has opened up this loophole that anytime they don't want to reveal terms of a contract, they can simply cite Boeing. And in our case, I mean, we've requested contract information from the University of Texas with ride-sharing companies, Uber and Lyft, and immediately got Boeing cited in a request for an AG opinion, which was sided with. I've looked at a lot of government contracts and they don't really reveal a whole lot of trade secrets in the contract itself. I mean, there are other terms and stuff, but when it comes to the contract, how much we're paying them, and what we're paying them for, how in the world that reveals any trade secrets, I'm not really sure. There's a long list since Boeing happened of the ridiculous things that people can't have access to. When the city of McAllen cannot know how much they paid Enrique Iglesias to play a concert, simply because they're citing, well, we don't want other cities to know what we're, getting paid because they may want to lowball us. And I guess that's their thinking. I'm not really sure. When taxpayers can't know what a school district is paying a food service vendor and what they're paying them for. I mean, the list goes on, and we could sit here and cite plenty of them, but these are some very ridiculous examples. And it's really has evolved with the privatization of government services, and I think that's where we've somehow got to strike the balance with, if you're going to come into business with government, then private companies need to understand that there is a transparency element involved with that business.
That's absolutely true. And I think even beyond that, we're seeing government agencies extending the competition argument beyond even working with public entities. I mean, beyond working with private entities to with public entities. In the city manager search, the argument was that they were competing with other government entities for the same candidates. So it wasn't even a private, private situation. And, they were arguing that they were competing with other cities seeking city managers at that time in Texas and in the United States, and there were no other cities seeking city managers that were even a tenth the size of Austin, and so you can basically spin a competition argument on absolutely anything, and I think that's exactly what we're seeing happening with Boeing.
Well, I'll second what he said about the privatization aspect of this. Part of what we were writing about is the privatization of Medicaid, and it's tens of billions of dollars that's going to outside companies, and the moment something is privatized, the inner workings of that go dark to us as far as the TPIA is concerned. But those contracts and stuff at least have reporting requirements, and there are contracts that outline, how they're supposed to perform and all those sorts of things. Well, Boeing just moves that line past that as well. So it's like not only can we not see the inner workings of these privatization efforts, but we can't even see sometimes the interactions or the or the regulation of these private companies. And I think when you really see it at its most infuriating is when you do what we did several times, which is say, I want all of these, I want all of these disclosure statements, for example, that all of these companies sent you, 15 companies, and we would get back, maybe 12, 13 different letters, everyone saying that a different thing was subject to Boeing. And what we ended up getting back was, 15 disclosure statements redacted in 13 different ways, because everyone felt like something else was, so which just shows you that it's not just that it moves that line in terms of what's privatized, it defers in a way that the company that's the subject of the request is really getting to have this outsized say over what ends up actually coming back from the agency. And, you know, it's really popular, I think, to beat up on the AG or on, you know, or on the agency, but I mean, really, this is something that without a legislative fix does not change. You know, everyone's following the law. I mean, it's just a really, it's just a wild ruling. Yeah.
And the effect, it seems to me, is the effect of Boeing is to defer to a governmental entity's claim of trade secret or competitive disadvantage, that sort of thing, and defers to the very governmental entity that the statute is supposed to be regulating in terms of public access. And so there is this, it's being used, you know, we say in the law, you know, it's sort of like nut grass. You have to poison it, otherwise it'll be everywhere. And so Boeing is sort of like that. If we don't, if there's not a legislative fix, now the driver's license issue, a lot of us will say, well, the one court of appeals that addressed it just got it wrong. In other places, somebody will litigate that in another court of appeals, presumably, and they will get that right. But that too has metastasized. And now there are attorney general opinions following that one court of appeals case that many of us think they just absolutely got it wrong. And Boeing, for now, we distinguish it. We say that the court doesn't say there's any difference. The court found on those set of facts, but you got to get all of that. It's hard for reporters on the ground to get that information without some sort of a court order. And by the time I see it or other lawyers see it, it's only the rare case where a case can actually be litigated to vindicate the public's rights to those sorts of things. And that's a problem also. How do we get these things accomplished? I guess by picking and choosing the right cases, but by having an appealing set of circumstances. But it is a way that I see, I think we were talking before, for news gathering organizations to be seen in a way that's counter to what some in this country have done to impugn or delegitimize the gathering of information for the public's benefit. And so my sense is that when news gathering organizations are trying to end secrecy in government or to force governmental entities to do what they're supposed to do, they see the press and news gathering organization in a completely different light than what's being portrayed when they watch, you know, cable TV with all kinds of viewpoint-oriented content all the time. So it is one way, I think, that the Sunshine Coalition can actually bring people in of different views when it comes to that specific issue, because it is something that the public really does support. And well, I don't know, was it Woodrow Wilson, whoever it was that was talking about government should be all outside and none inside. Well, the outside is the public. It's the insiders, that 10% that have built Boeing, have built this obstruction that we see every day.
So going back to Boeing, it's not, you know, we've talked a lot about how it impacts news organizations. Is there also an aspect here too of, you know, these contracts and, for example, bidding by, you know, other businesses that have lost out on contracts? It's not just a public information thing from the standpoint of news organizations, right? It's also, you know, for other people who need that access to that information, whether it's, you know, smaller businesses who may have lost out on bids on contracts or something like that. I mean, is there more to this in advocacy or, you know, for the purposes of addressing Boeing than just kind of talking about, you know, the access of news organizations?
Well, it seems to me, public vendors, we always thought that organizations that do business with governmental entities have less privacy and less containment of their business, simply because they are trying to do work for public entities. That has sort of been turned upside down to a certain extent. But the public, I think, in the legislature, I think ought to address this, is that when a governmental entity outsources governmental activities all of those activities are subject to the same open government law that Texas has, that they can't do, that people should not be able to do something indirectly, what they can't do directly. That's a tenet that people agree with. The law has said that for years, but we are seeing now that this is just one complicated web of resistance on the part of some governmental entities, and unfortunately, some of our larger ones. I think somebody made the comment that small governmental entities are ones that are less likely to be stubborn or less likely to be hiding information. And, you know, and that's those are my clients, or small cities like Seadrift. You know, what's the point in not letting taxpayers know what's going on at City Hall? It'll keep you from making stupid mistakes if people tell you what they think before you do it. I mean, these are all common sense propositions, but it is true that it's in the larger, the Amazon, the cities, the city manager in Austin, those are large cities. Those are big entities, and this, somehow this cottage industry of sort of obstruction has to be eased back into a conclusion that we are all better when the public has better understanding of how government works and how it spends money.
Amen to that.
Elizabeth and Andrew, I want to come back to you a little bit too, because we talked ahead of this panel just a little bit about things that you kind of learned and takeaways from, you know, not that there was anything you could have done in the moment, but just things that you learned as a result of kind of what you went through in reporting out these pieces. Could you talk a little bit about kind of takeaways and things that you've learned to do, you know, the next time you're running into this?
Sure. So, I think one of the biggest takeaways for me is I've always been of the mindset that, you know, you go to the agency first and you sort of initiate this conversation. You try to work in good faith toward getting the data or the records or whatever it is. And I've sort of learned in this that 10-day deadline is really the only thing that you really have in your pocket to keep things on track, and that starting the request is the only thing that starts that clock. You know, so I think there are a lot of cases where I would have sent the request and immediately followed it up with a phone call rather than doing the opposite. Especially like I said, when it comes to things like data that are just that just take, you know, forever to just actually form the request. The other thing that I'll say is, you know, kind of what I said earlier about data. It is really difficult to get data from a lot of agencies, and you know, some of it is because it's difficult for them to get it out. You know, they have vendored software that is really difficult to work with, and all those sorts of things. But I would say that I learned a lot about getting the data and what the shortcomings of the law are when you're trying to get data out of an agency. Specifically that, you know, we still don't have a way to ask, using the Public Information Act, what form is the data that you have in your data warehouse, you know? So you can sort of get into this case where you're just shadowboxing because, you know, it says, well, you know, there's a bunch of protected health information in that database. Well, show me the fields and let's see if we can take some of those protected fields out and still make this useful for the public. But if you send a request asking for the fields, that's something that they can successfully challenge to the Attorney General and win on, you know. So you end up in this case where you're just you're shadowboxing. You know, you don't know what they have, and they can sort of string you along. You know, in perpetuity on that. So, and it's not a blanket comment about state agencies. I mean, a lot are very open and transparent about these things, but the law is not kept up in that area.
Yeah, if I can jump in on what you just said right there, because there are general counsels in this room that I've known and worked with at various agencies for years who do a very good job of helping get the information that they are legally able to provide to requesters. And so I definitely just kind of want to make sure that this isn't a blanket statement across everybody. The resistance is there, but there are some folks that do a good job of helping the information flow.
Right, and there's an assumption that, you know, there's staffing at agencies that are able to, you know, there's a, you know, trying to accommodate all, you know, a lot of requests, a lot, you know, it's a lot of labor, and sometimes it requires, you know, more than just, clerical work. It requires, you know, a lot of computational work too. So this, you know, certainly that's an aspect of this too, to address those. Sorry, John, I'm coming back to you because I wanted you to talk a little bit about, you know, another client of yours in the case that you kind of referenced earlier related to the Calhoun Port Authority, and just kind of what, you know, just a little bit about what's going on there, and just kind of, you know, what you're dealing with a former congressman.
Well, we heard in the prior panel that sometimes our adversaries, those who do not want to comply with either of these two acts, have large budgets. And that too is a very visceral issue among the public, but that is what the newspaper and the public has faced in that case. And
this is the Victoria Advocate.
Sure, is a very competent, vigorous, scorched earth mentality about the whole case. And in fact, it's already on an interlocutory appeal before, that was done a week before a jury trial was set in that case. And now it's at the 13th Court of Appeals in Corpus Christi. But it's been a lesson in, you know, this notion of insularity, because this particular governmental entity is very, very insular, very, very public unfriendly. I mean, no agendas on their website, no easy access to agendas, minutes. The meetings are in weekdays when most people have to work. And they largely, you know, are not used to people asking them any questions. And so, in any event, it's an Open Meetings Act case that has proceeded through discovery and was ready for trial on the issue of the inadequacy of the notice to select a former ex-congressman who had been declared by the governor as being disgraced and as being a welcher by the Speaker of the House in terms of not paying back the taxpayers' monies that was spent, public monies that were spent paying off one of his former staffers in a federal lawsuit against his office. And so the defense is making a vigorous effort for a law change. It's a frontal assault on Cox versus Austin Independent School District, Cox newspapers. That their construct of the law is the only way that we have to give any detail about what we're doing about a personnel matter is if the position involves FaceTime and policymaking. It appears to us, we've said it in our pleadings, and the district court appears to agree that is a ludicrous argument. That's not what Cox said. Our analogy was, normally you wouldn't have to disclose that you were hiring a middle school coach, but if it was the guy from Penn State, Jerry Sandusky, that you were thinking of hiring, that would be of public interest, and the public should be alerted that this sort of person is being considered for the job. But you see that sort of attempt to make new law, and so that's what's happened. Joe, I think Joe's got it.
I'll just repeat the question so everyone can hear it. I think, Joe, you asked about elaborating more on on Cox, just to kind of the context of that.
Sure. The Austin School District, back in the 80s, I believe, attempted to conceal from the public that it was considering hiring a superintendent and what they were going to do with the superintendent, and the agenda didn't give the public any notice of that, and didn't give the public any notice that they were going to be talking about a lawsuit, a desegregation lawsuit. They just put litigation and personnel. The Supreme Court, vindicating the Texas Open Meetings Act, simply held that hiring a superintendent is not ordinary personnel, and that maybe litigation over a collection matter of a few dollars, maybe the public's not interested, but you're talking about a major desegregation case that the public could have some interest in, and found that the district had violated the act, declared that they'd violated the act, and refused to entertain any specific test or a cookie-cutter recipe for how public interest is determined. And they just said a common sense holding was, you're hiring a superintendent, the public has a right to know what you're doing. You're settling a major lawsuit, the public has a right to know what you're doing. And so Cox is the law of the land. It is still cited in every major piece of legal literature on the subject, and has been followed by the courts of appeals. But there is this cottage industry of trying to carve out exceptions to Cox. One lawyer, and I think Chris, was in the courtroom when the lawyer said Cox was basically wrongly decided. They should not have held that because this, these were not no showing of public interest in these positions. So that's sort of where we are. It'll be briefed. I think our intent is to file a motion to expedite. I don't think that's anything privileged. The court knows we think it's a 1 on a scale of 1 to 5 in terms of complexity. And time is of the essence, because this is what happens when there's delay. The taxpayers are paying Mr. Farenthold $13,333 a month during the pendency of our action to reverse his hiring, and there's no way to get that back. And so time is of the essence, but my sense is that even now, sometimes litigation is the only way to make a difference. The American Statesman made a difference in Cox. It's made a difference in a lot of ways. Yeah, we face a lot of headwinds now, but it's still the law. And we need to be vigorously defending that and continue to want to try the right case to get good law.
Okay, I think we've got a few minutes for questions. Does anyone have any questions? If you raise your hand and just shout out, use your outside voice, I'll repeat them up here. Yes, sir.
Thanks for the,
Just to quickly repeat, to ask about the responsiveness of agencies in other states and how they compare.
But I would say that Texas was, for the specific, we were basically requesting the exact same thing in a bunch of different states. And it was a fishing expedition. We knew that a company operated in multiple states. It was sort of a needle in a haystack thing. And I would say that a lot of them, Texas has that 10-day deadline. I mean, there were several of them that we interacted with where it was more like 25 or 30 days. And we got documents beforehand, but there were some that were less responsive, absolutely, and then there were several where the process of sort of prodding them or challenging their decision was substantially more complex. There were some that worked more like the federal system where you have an internal ombudsman and those sorts of things. So I felt like a lot of them were less responsive, but maybe that's just my comfort with the Texas system. We did have several records in Florida that we tried to get, and obviously the Florida laws were great. But there were several states that I would say were harder to work with than Texas. Yeah.
Andrew, to follow up on what you're doing, lawyers we're usually behind the media in terms of gathering information, but the federal rules that we use in federal court, now we don't shadow box anymore. There are upfront requirements that the responder identify whether the documents are ESI, electronically stored information, paper, or what the native format is, and what the discovering party has a right to. It seems to me those protocols, normally we would get less in pretrial discovery than reporters could get from public entities. But if those protocols have already been worked out for lawyers, why in the world would we not consider asking the legislature to update the Public Information Act? Because information in 2018 and 2019 is a completely different ball of wax than we had, what was it, Article 62, 52, or whatever it was back in the day when we passed the statute. Information's kept in a different way, And reporters should not be shadow boxing to get public information. And in federal court now, federal judges will require a responding party to tell you whether they have scanned papers instead of giving you native format or PDFs that are directly output from their native format, so you can search and make use of those dozens of thousands of pages. So it's an idea at least to consider, I think.
Absolutely. Yes, sir.
Someone repeat the essential determination.
Repeating the essential determination of the Boeing ruling. Who wants to kind of
You're the lawyer.
This is a public forum, though. Boeing and the Greater Houston Partnership cases, the gist of those cases is that governmental entities can claim a competitive disadvantage in giving information to the public about projects, about subject matters. In the old days, they could obviously keep their settlement negotiations or strategies because it would directly interfere with the government's ability to settle a lawsuit, or even a real estate deal that's currently in process. You don't want your bidding strategy out there to the other side to run up the price. But Boeing has, on what I thought to be a very weak showing of governmental necessity of keeping this information private or within the government, and essentially allowed governments to simply stake out a position that it would hurt them in some nefarious way in their competitive competition, things like that. And so these cases, I mean, Boeing it's out there, the genie is out, you know, lightning has struck, it is what it is. But at the same time, the legislature has not been shy about correcting the highest courts in the land when the public and legislative bodies think they got it wrong. I believe they got it wrong. Many people think they got it wrong. And I think a lot of legislators think they got it wrong. The outside thinks they got it wrong, the inside says it's okay. So that's the way I see it.
And the process is worth noting because it wasn't gotten wrong until it got to the highest level. The AG ruled that that information should be disclosed. Local courts on appeal ruled that that information should be disclosed. The appeals courts ruled that that information should be disclosed. By the time Boeing pushed it all the way to the top is where, all of those determinations got overruled.
Well, I see it as sort of, maybe if we're run out of time, I see this as courts, sometimes in the constellation of an insular decision, can really get things wrong. I mean, in my life, I've seen the Supreme Court of the United States say, the more a person overcomes a disability, even if they're missing a leg, they don't have a disability at all. Well, the public wasn't going to stand for that. The legislature wasn't going to stand for that. Congress didn't stand for that. And they fixed it. People with missing a leg now have a disability and can't be punished for succeeding. I see Boeing in the future as something that's going to be mitigated legislatively if the right coalition, if we get the right people to talk with the legislature and work it through. And it may not happen in the next session, but it's going to happen at some point, because otherwise you end up with the whole world upside down, that the governmental functions are abdicated to private companies, and the public doesn't have any access over their own information.
I think we've got time for, yes, ma'am. Just to quickly repeat the question, I'll just condense it a little bit. Related to electronic information, there was an example cited of, when a request was made about, related to texts, and then was the information officer or someone said to wipe the text off the phone. So what are the legality around that?
Under those circumstances, I'd be at the courthouse to make an argument that they failed to preserve information the law required them to preserve, especially when the motive is to conceal information that would arguably be subject to the Public Information Act. I mean, that is what we used to call spoliation. It's a doctrine that penalizes harshly those who intentionally deprive the public or opposite parties of having information that's necessary to a resolution of the case. in the law, that's a horrible, horrible thing. And, you know, you have to be in a,
How do you prove it? How do you prove it?
how do you prove that somebody deleted the messages? Well, I think I would defer to Andrew, but we image cell phone drives, we image storage media, we have forensic analysis on what happened to those text messages, when they were removed, but I think I'd defer to them. But I know that people don't usually get away with it when they try to delete text messages and emails, and federal and state judges have been harsh on parties who have done so.
I would just say that I've seen the same thing, not only in the Valley, but also in Dallas and in larger places. And I think it is really difficult to prove. Maybe it's not difficult for, you know, someone with a subpoena to prove, you know, that texts have been deleted, but there's no way for me to prove it very easily. I had a situation where a coworker had requested some texts from a lot of elected officials, and one elected official went to another one and advised her to delete them all and said, you know, the newspaper will have to sue you to figure out what happened, and they're not going to do that. They can't prove it.
I think we have time for one more question. Yes, sir.
I think, Dave, mainly it's done behind the scenes. I mean, I'm a member of TML. I am a city attorney. I never hear them at meetings explaining how to avoid the Open Meetings Act or the Texas Public Information Act. But at cocktail receptions, the stories are told how my stupid client went all running at the mouth and got caught, and it was very embarrassing. And so we're not going to record any more of our closed sessions. And, you know, the less detail on the agenda, hell, my clients get upset. There's 50 people show up in the audience, and then they're belly aching, and then we have public forum that's going to last an hour and a half. That's the kind of thing that I think it breeds, not at the top. I don't think it breeds, if you look at TML's, TASB's, and maybe Texas Associated Counties, guidance on open meetings, they're good. In fact, we use them in court. That we say, this is what TASB says. TASB says you can't conceal this from the public. But when you go to local school districts, you talk to their lawyers, it's like, oh, my client, they're doing all kind of stuff. I got to figure out a way to not get them in court. I'm just going to just try to skate beyond all of that. So I think that's where it happens. And I think it happens, certainly don't want to stereotype, but some lawyers have a goal of weakening open government. That's part of the cottage industry. We're seeing it in this case, trying to make new law to just gut the requirement of the statute to adequately notify the public of matters that will be discussed or deliberated at a meeting. And so that's the cottage industry. If I knew how to put Roundup on that nut grass, I would have already put it there.
Everyone, please join me in thanking this wonderful panel. Appreciate it.